but for all of the families. Ms. Barbirou, if you could proceed.
Just to inform you, my testimony will be paraphrased, and I do request...
Did you put on your...
I did.
What's on? Okay.
I said just for the record, my testimony will be paraphrased, and I would request that it be submitted for the
Okay, without objection, yours and all the other statements and any additional materials you'd like to have attached to your testimony will be made a part of the record.
Thank you. Chairman Smith, thank you for committing your time today to address this issue of international parental child abduction and the implementation of the Goldman Act, henceforth referred to as ICAPRA. I am inspired by your continued concern for the pursuit of justice in the cases of our illegally abducted children. Without your constant vigilance over ICAPRA and its implementation by the Department of State, I and the thousands of others who have been victimized by IPCA would be all alone. Many of us have spent years begging to be heard, to be properly represented for the sake of our children by our government. Thank you for answering our plea. In my family's case, my children, Eslam and Zainab, were illegally abducted to Tunisia by their father, a Tunisian native, in November of 2011. At the time, I had full custody of both children and retained a judicial order preventing either of us from traveling outside of the United States with either child. Because there are no formal legal agreements between the U.S. and Tunisia, I relocated to Tunis in January 2012 in order to pursue the application of my custody rights through their courts. In October of 2012, I obtained a Tunisian primary court ruling upholding my rights of custody of both Eslam and Zainab in the United States. That ruling was appealed, and I later obtained concurring judgments through both the Tunisian appellate and Supreme Courts upholding my rights of custody of both children, declaring that their best interest would be served by their return to the United States, their home of residence. Despite all of these judicial decrees, the Tunisian government has refused to implement its laws, and these rulings remain unenforced to this day. Prior to the passing of ICAPRA, State's Office of Children's Issues, or OCI, the U.S. Consulate in Tunisia, the U.S. Ambassador to Tunisia, and Ambassador Susan Jacobs had been very active in our case. This support, coupled with the avid representation I've received from Senators Cardin and Mikulski, and the FBI through its legal attaché in Tunis, assured me that with the passing of ICAPRA, our case would be immediately resolved, and our family would be reunited here on U.S. soil. Unfortunately, that is not the case. Despite having every available tool at its disposal to secure the return of my baby, he remains illegally retained with his father in Tunisia. I firmly believe that this is due to intentional resistance on behalf of state to ICAPRA and the likely unpopular diplomatic and political consequences of its full enforcement. I defer to the compliance report to support these claims. I'm thankful that in its testimony today, State has provided an account of how many children have been represented by the report. While the report makes consistent references to cases throughout, there is not one instance where an abducted child is counted. My question is simple. Why? Why wasn't a single child accounted for in 2014, and how did the Central Authority for the United States lose sight of the significance for every searching parent that it represents to have his or her child counted? After scrutinizing the 42-page report as submitted to Congress, I have no clearer understanding of how many cases of IPCA occur in the United States, how many children are affected, and no means of assessing whether the numbers of abductions have increased, decreased, or remained the same. Simply providing evasive accounting of cases without identifying a total number of children affected does not bring us any closer to an understanding of the breadth of this crime on the American public. The compliance report is riddled with gross numerical manipulations, as exemplified by a cursory review of the Tunisia section of Table 2, where neither the unresolved case of Eslam nor that of Zainab, who returned home with me in August of 2014, appear to be represented. Aside from this, the report also explicates State's disinterest in pursuing the stronger remedies required by ICAPRA. It also clearly articulates its policy of increasing the number of signatories to the Convention as its major goal. This policy of pushing the Convention as a remedy has not been shown to affect a resolution in any existing case, and I believe the devastating repercussions for our families with abductions to Japan provide strong evidence of that. To be clear, ICAPRA, as it is written, is a fair and powerful law that includes strong remedies which, if applied, will result in the return of our illegally retained abducted children abroad. It is my firm belief that had State applied any of remedies 4 through 7 as provided for in Section 202D of ICAPRA, Eslam Chebbi would be home with his family today. The policy and directive of OCI to promote accession to the Convention and to avoid politically and diplomatically contentious remedies for the return of our innocent American citizens speaks volumes. At this time, my baby is a vulnerable United States citizen who is being denied his constitutional rights under Tunisian law, international law, and U.S. law. And despite the extensive efforts of the various representatives of State, my United States senators and representative, the FBI, and legal counsel, the Tunisian government continues to issue our case while opening its pockets to the ever-increasing financial allotments that State provides to the Republic annually. Clearly, if Eslam Chebbi counts, and if every American child illegally retained abroad accounts, then State must redouble its efforts to account for every abducted child in its report and apply every actionable remedy provided for in ICAPRA to ensure their return. As you well know, there is so much more that can be said about this very important topic, but given time constraints, I must conclude my testimony here. So I thank you again for the honor of testifying.
Thank you so very much for your testimony. We will try to have an additional hearing in July, because there is a 90-day window where the application of the sanctions, hopefully there will be significant and robust sanctions against those 22 countries, and I would hope that they will revisit Japan, as I mentioned to our 2 previous panelists, because Japan absolutely has to be on the list. It is a glaring omission. I'd like to yield, before going to Mr. Parmar, to Elliot Engel, the ranking member of the full committee.
Thank you, Mr. Chairman.